Thank you, ladies and gentlemen, for joining us today. I am joined by my colleagues, Arizona Attorney General Chris Mays and Michigan Attorney General Dana Nessel, to announce that we, as lead counsel in representing a coalition of 14 states, have filed an action in the district court in the District of Columbia to seek an injunction against the actions of Elon Musk in his capacity as the DOGE administrator. For the better part of 3 weeks, we have witnessed now a fundamental restructuring of our constitutional order and a violation of the rule of law. We have initiated this action in part because the things that we have seen and witnessed on the part of Mr. Musk fundamentally reshape our understanding of the limitations of the presidency. Simply put, the American people did not vote for chaos, they did not vote for disruption, and they did not vote for Elon Musk. The core of our argument is that this empowerment of Mr. Musk violates a core principle that is centered in the Appointments Clause of the United States Constitution, which guarantees the appropriate balance of power between the three branches of government. Specifically, in the creation of DOGE and the creation of that office, President Trump has sought to elevate an agency which was primarily responsible for the maintenance of government websites into effectively a department of everything, and placed at the head of that department an individual who has not been submitted to an inquiry and a vetting by the Senate and has not been subjected to the advice and consent clause of the United States Constitution. In doing so, Mr. Musk, by the authority conveyed to him by President Trump, is exceeding all boundaries of the proper scope of presidential power. And it goes to the core of something that has been a key concern of Americans throughout our history. Our constitutional order was founded in part to guard against the accumulation of state power in the hands of a single individual. And while that construction was first focused on the abuse of power of an 18th century monarch, it is no less dangerous in the hands of a 21st century tech tycoon. And for those reasons, we have joined together to take an important first step to push back against the unlawful authority that has been granted to Mr. Musk. And we hope that this action will enable the courts to truly evaluate the extent to which Mr. Musk has the operational authority and the constitutional authority to engage in this. We take this action not as members of a political party, but as the chief legal officers of our state who have sworn to uphold and protect the Constitution, including the core values that no one man is above the law and no one person should be granted the authority to dictate how the American government should function without first including the representative branches of our democracy. This is an important issue. It is a novel question for the courts to consider in this context, but we are in uncharted territories with the disregard that has been on display over the last several weeks. I'll stop there and turn it over now to my colleague Chris Mays for some thoughts. We will then hear from AG Nessel and open it up for your questions after that. Thank you.
Thank you, Attorney General Torres, and thanks for everyone for being on with us today. The founding fathers of this country would be outraged that 250 years after our nation overthrew a king, the people of this country, many of whom have fought and died to protect our freedoms, are now subject to the whims of a single unelected billionaire. The actions of the Trump administration in the last 3 weeks can only be described as dictatorial and authoritarian. Every day, nearly every hour, there is some new action or executive order that makes a mockery of the rule of law and the Constitution itself. I want to be as direct and clear as I can be. There is an undemocratic administration in power, and they appear hell-bent on undoing 250 years of adherence to the rule of law in this nation. We are in an incredibly dangerous moment, and it is all the more dangerous if everyone does not understand what is happening. There is an ongoing coup against the Constitution of the United States happening as we speak. That is why the Democratic attorneys general are once again stepping up to defend the rule of law in this nation and suing Elon Musk and Donald Trump for violating the Constitution. Just days ago, Elon Musk announced he had abruptly, quote, canceled $900 million in legally awarded funding at the Department of Education. He did this with no transparency and no metrics for why this funding had been canceled at apparently his discretion alone. Well, sorry, that's not how this works. Congress authorizes the work of federal agencies and allocates funding to them. The elected representatives of the people are supposed to exercise oversight to ensure that these agencies operate within the bounds of the law, serve the public interest, and are held accountable for how they use taxpayer dollars. But today, Congress is nowhere to be found. Donald Trump has grabbed the power of Congress and has handed it to an unelected billionaire. The richest man in the world is now running roughshod over the authority of federal agencies in violation of the rule of law and the Constitution. This is not how our system of government works. It is a blatant and egregious violation of the rule of law. Our democracy was built on the fundamental principle that no one is above the law and that there are three co-equal branches of government. We don't have kings in this country, and we don't have billionaire dictators. We have elected representatives that swear oaths to defend the Constitution. Allowing one individual to flout the law without consequences threatens our entire constitutional system. We cannot allow our democratic processes to be hijacked by immense wealth and privilege. Republicans hold majorities in the House and the Senate. They could pass the administration's policies through Congress and send President Trump legislation to sign. But they know that the American people don't support what is happening. They don't support eliminating the Department of Education. They don't support canceling funding for law enforcement and public safety, and they do not support canceling funding for health care. So instead, Donald Trump has decided the Constitution does not matter, and he has handed power to Elon Musk to do whatever he wants without accountability and without oversight and without the consent of the people. The way we make change in this country is through the law, either in the courts or in Congress. And when those processes are undermined, when the rule of law is ignored, manipulated, or twisted to serve the whims of an unelected billionaire, it is an assault on the very foundation of our democratic republic. We will not be the generation that lets the light of liberty go dark in America. We will not allow our constitutional form of government to devolve into dictatorship. And we will not let the world's richest man dictate the policies of the United States government without the consent of the people. Thank you. And now I'd like to turn it over to the Attorney General of Michigan, Dana Nessel.
Thank you, AG Mays. Thank you. And thank you to AG Torres for your incredible leadership on this gravely important issue. The concern surrounding Elon Musk and DOGE's overreach has been reverberating all through the state, all through the country. And one thing we can say is this: it impacts everyone, literally everyone. This issue is right now, by far, the largest and the most urgent concern of the individuals, Michiganders, who have been reaching out to my office, and their concern obviously is incredibly well placed. This assault on our federal government by the unelected, unappointed billionaire Elon Musk usurps the right of the Senate to advise and consent and is plainly unconstitutional. And it's the unconstitutional exercise of authority by Musk that is harming the residents of Michigan, and I would argue of all states. And that is why today we are asking this court to invalidate his directives and actions and to issue a restraining order barring Elon Musk and the so-called Department of Government Efficiency from exercising any governmental authority reserved for officers of the United States over any other agency in the executive branch of the federal government. This far-reaching and unauthorized intrusion metastasizing throughout the federal government has literally terrified our residents, and it's left them feeling hopeless and paralyzed to protect themselves, their personal information, critical funding, programming, and jobs that they depend upon. You know, when Trump was inaugurated just 3 weeks ago, I pledged to the people of the state of Michigan that if and when this administration engaged in conduct that was unlawful and caused harm to Michigan residents, that I would act. And I can think of few examples more egregious, really, in history than that has been exhibited by the conduct of Elon Musk and his DOGE associates. So we are seeking a temporary restraining order that immediately orders DOGE to halt all operations that provide them with access to personally identifying information or other confidential information, and to destroy any documents already procured that contain this type of information. Now, to date, I think it's been, 18, 19 federal agencies that have been infiltrated by Musk and his associates, some of them including the Centers for Medicare and Medicaid Services, Department of Treasury, Labor, Education, Energy, Defense, the Centers for Disease Control, and now reportedly, I read today, the Internal Revenue Service. The databases of these agencies were accessed without the necessary security clearances or best practices to ensure data security. And the data that Musk and his associates can now access, I mean, especially through the Department of Energy and Defense, presents significant national security risks, both through the nation's nuclear energy programs, as well as every detail of our Department of Defense that they're entrusted with, from the location of our troops to confidential plans for military responses around the globe to any number of foreseeable threats. And these aren't just my concerns. I mean, these are the concerns of thousands and thousands of Michiganders who have reached out to my office and pleaded with me to please take action. And as one of my constituents wrote, the handling of personal and sensitive data should always prioritize transparency and strict adherence to privacy laws to prevent any unauthorized access or misuse. Now, we're talking about personal identifying information that each and every American is required to entrust to the federal government, from our Social Security numbers to billing medical codes for Medicare and Medicaid, supporting our health care, to the intelligence gathered by our defense teams. Michigan residents are afraid that they will lose access to healthcare treatments, prescriptions, and even their Medicare and Medicaid coverage. And they're afraid of what could happen with the data that's stored by the Social Security Administration for their retirement benefits, their banking information that they provide to the IRS. Quite frankly, they are afraid of where Elon Musk will go next. And due to the complete lack of transparency in his actions, we can't ever truly know what he has access and may never know the depths of his reach. DOGE shares only what they choose to on their website, which is very limited, and on social media, and they're not subject to FOIA. And of course, the majority of Congress seems virtually uninterested, uncurious, or perhaps too afraid to subpoena Musk and his DOGE associates to testify and answer incredibly simple questions, right? Questions that every other elected official would be obligated to respond to. As we allege in this complaint, Musk has unprecedented and seemingly limitless access across the federal government. He reports solely to President Trump, if he reports to anyone at all, most of the time. And he's exercised significant and sweeping authority across a broad swath of federal agencies. And he's exercised a constellation of powers that can only be exercised by officers of the United States, including powers over spending and disbursement, contracts, government property, regulations, and agency viability. As we've seen from previous cases and ongoing communications from both Vice President Vance and Elon Musk, this administration behaves as though they are above the law and beyond the reach of judicial authority. And for his part, Musk has said or shared statements to the effect that court rulings against his will should face consequences and that judges who interfere with Musk's plans should be impeached. Despite their actions and assertions, the executive branch must comply with court orders and they must abide by the law. And that is a fundamental tenet of separation of powers and one of the most significant protections the founding fathers knowingly, intentionally placed into the Constitution to protect us exactly against this exact type of government overreach. And what's more, our Congress should be absolutely embarrassed by this clear usurping of their rightful powers. I can't imagine why members of Congress aren't outraged to see their responsibilities and authorities stripped away and handed to the president's wealthiest benefactor. And their lack of action motivates us even more to take this action to the courts, because if we've already lost the legislative branch, it appears we have, we can only pray that we can keep the judicial branch as a check and balance to the utter lawlessness of this White House. Already, the number of restraining orders and preliminary injunctions granted by the Democratic and Republican appointed judges alike has been astronomical, but it speaks to the total and complete lawlessness of this president and those who act at his behest. And myself and my attorneys general colleagues merely demand one thing and one thing only, that the president and his administration obey the law. And with that, I'll kick it back to you, A.G. Torres.
So I want to thank Attorney General Mays, Attorney General Nessel, and the 11 other colleagues who have joined this action today. I know there are probably a number of questions, and so I'll open it up to answer any questions that you may have.
All right, before we begin with questions, just a couple quick notes. As a reminder, we do have our 3 attorneys general with us today from Arizona, Michigan, and New Mexico. That's Arizona Attorney General Chris Mays, Michigan Attorney General Dana Nessel, and New Mexico Attorney General Raul Torres. Before we call on you, just wanted to remind you guys, keep your questions on topic and please announce your name, outlet, and direct your question to a specific attorney general, please. And our first question is going to go to Lily. Lily, go ahead.
Guys, this is Lily Gwinney from Gongwer News Service in Michigan. AG Nessel, this is directed to you, but anyone can feel to add to it. We've obviously seen in the past couple weeks, as you touched on slightly there, comments from the vice president, the president, insinuating that the legal stays put on the federal government at this moment in time are in themselves perhaps unconstitutional. We know that to not be true, but what if any legal recourse is there to ensure that court orders that restrain functions of the federal government that are coming from the White House actually are followed? And we know that certain orders have not been obeyed at this point in time. Is there any way to stop that from happening in the future?
Well, I certainly hope so. Otherwise, we are certainly in the midst of a constitutional crisis. Historically, what's happened is, the government from time to time does, whether it's intentional or not, abuse their authority. And if so, they can be held accountable in the courts. And what we expect, what we demand, of course, is that any party that's enjoined, especially the federal government, that they obey and comply with court orders. If they don't, then of course, you can bring a motion to enforce, as was done on the case involving the Office of Management and Budget. And you can always show cause an individual who fails to comply with a court order. And generally what happens is they'll be asked to come into court, they'll be ordered to come into court and to explain their actions or their inactions. If there are allegations that that individual has not, in fact, complied with a court order. And if they refuse to come in, then, the U.S. Marshals generally are tasked with bringing that individual before the court, which we hope won't have to happen. But what my hope is on this case and on all the many other cases that have been filed where there have been temporary restraining orders in place or preliminary injunctions that have been granted, that the federal government will do what they've always done, which is to comply with the law. And I will say, for instance, I just saw recently on our NIH case, the National Institute of Health, which my colleagues, AG Mays and Torres and many others participated in that case. The NIH has already indicated, and they've sent out letters actually to all their grantees, that they are going to go back to the original contracts that had been negotiated and not the drastic cuts that were ordered to be put in place just last Friday night. So clearly in that case, they're saying we are complying with the law, and they've indicated it very specifically and very clearly. So we're hoping that the same thing will happen on this case as well.
All right, our next question is Beth LeBlanc. Can you please unmute yourself and ask your question?
Hi, Beth LeBlanc with the Detroit News. Thank you for taking these questions. AG Nessel, my question is for you. Governor Whitmer has declined to join several of these multi-state suits against Trump and has generally given a more muted response to the Trump administration's actions than she did during his first term. Can you speak to some of the discussions your office has had with her about joining these suits, or comment in general on what it means that she hasn't joined these?
Well, Beth, thank you for the question. But as you know, we are independently elected office holders. And, Governor Whitmer has her agenda and the things that are important to her. As for me, I ran on this in 2018 that I would hold accountable the federal government if or when they, committed trespasses against the people of the state of Michigan, and they violated the law. And in doing so, they injured the residents of the state of Michigan. That was my vow then, and it continues to be my vow. And I took an oath to uphold and defend the Constitution of the state of Michigan and the Constitution of the United States of America. And this case today, this is me upholding my oath of office. So candidly, I don't tell the governor what to do in her job. She doesn't tell me what to do in my job. This is something that I committed to the people of the state of Michigan when they voted for me the first time and the second time that I would do. And so it's me keeping my promise.
All right, our next question, Karen Tumulty. Please unmute yourself.
Again, thank you so much for all of this. Could you go back through a little bit of the logistics here? How many states are joining you, where you are filing this, and sort of the many actions we've seen of Musk and the DOGE? Was there like something in particular that kind of triggered this?
So Karen, let me start by saying we at last count have a coalition of 14 states that have joined this action today. And it is in a part of a whole range of legal actions that have already been taken by the AGs present here, but others who are not present on this call. And what I think prompted this particular approach to Elon Musk and the chaos and disruption that we have seen, the cancellation of contracts, the unilateral decisions that he has taken in shaping policy and frankly overriding the will of elected representatives in Congress. We came to the conclusion that we needed to take a comprehensive approach to him as an individual and to his role in the administration. As you know, the executive order that created DOGE was actually limited to a certain extent and placed him in charge of a small office within the executive branch that previously had been responsible for maintaining the IT infrastructure and the websites inside the federal government. But it became apparent relatively quickly that he was accessing information in the Treasury Department and in USAID, and the Department of Education. And with each passing day, there was, in our view, a new violation, a new betrayal of trust with the American people, and a new example of the disregard that he has for our process, for the American government. And I think part of that is rooted in this culture where he comes from of move fast and break things, right? Move fast and breaking things may work in Silicon Valley for a tech company. It's not good governance and it's unconstitutional. And it became apparent to us that we needed to take a comprehensive approach to stop this activity. And fundamentally, as AG Mays highlighted earlier, force the president to use his power in the way it was intended. And what I mean by that is relying on Elon Musk to romp around in all these agencies, smashing things, doing whatever he wants, is, I think, President Trump's view of an expression of his political power. He talks a lot about fulfilling a mandate, leaving aside the fact that I think he secured less than 50% of the popular vote. The actions of DOGE, the actions of Elon Musk, represent the president's political weakness, not his strength. If he had the mandate that he has and the political strength that he believes he has, then he should have no trouble acting as previous presidents have and working with leaders in Congress, leaders in the House and the Senate that are controlled and run by his own party. He can send requests for legislation to change appropriations, to trim the authority, perhaps, of executive agencies to conform with his policies, to create new agencies like DOGE or eliminate other agencies. But his fear, I guess, of going to Congress and using the proper legal and constitutional tools available to him, I think demonstrate a fundamental weakness in his position. And I think it is masked as a form of strength by unleashing Elon Musk on the American government and the American people. But if he has the kind of strength that he believes he has, he shouldn't have no problem advancing his agenda through Congress, which is the proper, an appropriate, and constitutional way to affect change in this country.
If I could just add to that, I think it's, as you will see when you read through the complaint, our complaint is predicated on the appointments clause. And I think it's really important to go back in history and understand, and we talk about this in the complaint, why our founding fathers created the appointments clause. They were worried about tyranny and a king-like figure in the presidency who could come in and unilaterally create positions and then fill those positions with his own people. And so they created the appointments clause that said that Congress must create positions of this level of importance that Elon Musk has obviously taken on, and that they must advise and consent to these positions. So I think it's important to remember that this is about separation of powers, as my colleagues have talked about, and the appointments clause in the Constitution, which was designed to buttress the separation of powers and guard against a tyrannical figure in the presidency.
All right, we're getting close to the end of today's press conference. I'm going to say we have Yvonne first, and then after that, Evans, McMorris, Santoro. Yvonne, can you unmute yourself, please? Be sure to announce your outlet.
Hi, thanks for doing this. Yvonne Winget Sanchez with the Washington Post. You have a large swath of Americans, millions of Americans who are going to view your actions today as politically driven and noise. Along with a lot of other noise that is happening. And I guess my question to whoever wants to take it is, what is your message to these Americans who may view your actions as political and, politically driven?
Could I just really quickly say, Yvonne, look, I think Dana pointed this out earlier. Our offices actually, quite to the contrary of the premise of your question, our offices have been inundated with people who are angry about what Elon Musk is doing, especially with regard to his and DOGE's access to their personal data and other information that they are clearly getting access to inside of this, of all of these agencies. And the phone calls, Yvonne, to my office are across the board opposed to what Musk is doing and span the political spectrum.
Can I follow up? Firstly, I'm going to say this on behalf of myself, and I think it's true for AG Mays and Torres and all of our colleagues that join in this lawsuit. There is no individual, even the most strident Democrat in the United States, had a Democratic president allowed a person to behave in this manner, we would bring this exact same lawsuit because we are so horrified at the flagrant violation of the United States Constitution and, of course, the unprecedented access that one person has to all of this information. A person, by the way, who has, incredible conflicts of interest and who has never been vetted and never been provided with a security clearance in order to access this information. And let me say this, I was thinking about it in regard to my department, right? Just the state of Michigan, just the Department of Attorney General in the state of Michigan. Even an entry-level secretary has to go through more intensive vetting than Elon Musk or any of his staffers at DOGE, right? You have to go through a background check. You have to go through a criminal history check before you're allowed to access anything at all. You have to go through really intensive training in terms of policies and procedures to make sure that you are keeping data secure and safe. And even then, you're only allowed to access certain things that pertain to your specific area of the office. You certainly can't just access anything you want all across the office. So to have one individual like this, who again, never an official appointment, never confirmed by the Senate, and he's allowed to go into every single portion of every agency, every department of the federal government. It's not just that it's unprecedented. I don't even know that the founding fathers could have envisioned or imagined that such a thing would ever occur. So this is the farthest thing from political that I can possibly imagine. And I guarantee you, if any Democrat was doing this, we would have filed this exact same lawsuit.
All right, Evans, and then our last question will be Jack Queen. Go ahead, Evans.
Yeah, hi, Evan McMorris Santoro from Notice. Just a couple questions. Number one, what would happen to Mr. Musk if you win this injunction? Would he be barred from coming to work or barred from doing the work that he's doing? And secondly, a little more detail on what you say is illegal about the president using the U.S. Digital Service, sort of expanding its mandate, why that is against the law? Thanks.
So Evans, thank you for the question. The answer with respect to what remedies are available to us, we have asked, and will ask the court to enjoin Mr. Musk from engaging in the kind of activity that he's already been engaging in, and to nullify any actions that he has already taken. So, for example, he's ordered that payments be stopped to American farmers who are part of certain funding programs for initiatives that have been authorized and funded by Congress. And apparently, President Trump feels that he has the ability to give Elon Musk a veto over congressional action. And so we are seeking both to unwind the harm that has already been done by this unconstitutional action, but also to prohibit him from engaging in that action in the future. And that speaks to the second aspect of your question, which really goes to the structure of not just our legal argument, but to the Constitution itself. As A.G. Mays referenced, abuses by the King of England and his ability to arbitrarily create offices and arbitrarily fill those offices with his own people was a grievance that was outlined in the Declaration of Independence. So this is an argument that is both new with respect to Elon Musk, but it is as old as our republic itself. I mean, it is part of our origin story, and it didn't just stop in the Declaration of Independence. They then took that same fear in founding and in constructing the Constitution and built into the Constitution, specifically the Appointments Clause, which creates and requires the advice and consent of the Senate. But it also clearly delineates that only Congress can create these departments, and then Congress must have a role in appointing and vetting and approving the individuals who are selected and vetted to do that. And the irony is that we have this parallel process where cabinet secretaries who I guess think they are actually in charge, submitting themselves to the formal constitutional requirements of their offices, and then they show up and they find out that the real boss inside these agencies is Elon Musk, because fundamentally neither he nor the president understand Article 2 of the American Constitution. They fundamentally don't understand or are unwilling to abide by the limitations of that office. And this goes to the last part. Our constitutional structure is as much about restraining the impulses of a single individual, because that is what leads to tyranny. That's what enables an unelected billionaire to assume control of the entire federal government. And there couldn't be a more obvious violation of a core constitutional principle than what we've witnessed in the last 3 weeks.
All right, our last question is for Jack Queen. Before Jack unmutes, and AG Mays has a follow-up, it looks like. Before Jack unmutes, if you have a question that we did not get to, please feel free to reach out to your respective Attorney General's office communications team to ask that question. AG Mays, did you have a follow-up to the question before?
I was just going to use my prerogative as an Arizonan to allow Joe Dana, who's an Arizona reporter, to ask a question, if my colleagues will allow it.
All right, so Jack and then Joe.
Jack McQueen. Or Jack Queen.
Sorry, I was muted. This is Jack Queen at Reuters, not from Arizona, from New York, but thanks for taking the question anyway. And this has sort of been answered. I was wondering initially, is this more broad and sweepy than the privacy lawsuits that we've seen against DOGE? It seems like it is. And so in that vein, I was wondering if you could just rattle off really quickly for us your prayer for relief, the remedies you guys are seeking, and also let us know when this is actually going to hit the docket and when we might get to see the complaint. Thank you.
I think AG Torres kind of covered that, Jack, but it does cover, all of the agencies, all of the federal agencies, and certainly the 18 or so that he has already infiltrated, and would prevent him from engaging in the activities that he has been engaging in. This is on page 56 of the complaint once it hits the docket. And we list a number of activities that we're asking he be enjoined from engaging in, and then so you can go ahead, Ro.
And Jack, at the conclusion, our staff will give you the PACER number and the case number so that you can find it. We will also provide a PDF copy at the conclusion.
But I agree. It is. I would agree with you that it is the broadest. It covers the broadest, the most territory of the complaints so far.
And at the request of AG Mays, it looks like Joe Dana has unmuted. That will be our last question for today. Go ahead, Joe.
Thank you, and thank you, Attorney Generals. Attorney General Mays, and for the others as well. The Wall Street Journal reported in October that Elon Musk had spent the last 2 years meeting regularly with Russian President Vladimir Putin. Can you comment on the seriousness of the national security threat you see? And barring an immediate action by the courts, is there anything else you see as a possible option regarding our national security? Thanks.
Yeah, Joe, thanks for that question. I mean, it's an incredibly important and concerning question. And, it's one of the reasons, obviously, we are going to be seeking a TRO, a temporary restraining order. In this case, we think that this activity by Elon Musk, who has been elected by no one, who is violating the Appointments Clause of the United States Constitution, has not been confirmed or vetted by the United States Congress, needs to be stopped immediately. And so that's why we felt the urgency of bringing this action now, and prophylactically protecting our agencies and really the information and data of every American, and protecting their health care, protecting all of the services that they receive, making sure our farmers continue to receive aid. All of these things are at risk, and certainly the data in the critical data inside each of these agencies we feel is at risk. So I'll throw it to my colleagues to.
I will follow up on that too, because this is a critically important question for New Mexico. As you know, this is New Mexico is the birthplace of the atomic weapon. We have two highly secured installations here, Sandia National Labs and Los Alamos National Labs, both of which are supervised by the Department of Energy. And we know that DOGE, under Musk's supervision, has gained access to certain systems. Now, because we don't yet have clarity on what level of access he's been granted, or whether or not security protocols that are required of all government officials are active and in place, I have very serious concerns about both the security of information that is being accessed, the way in which that information and data has been shared. We have reports that data has been shared outside of the agencies, and in certain instances has been processed by potentially artificial intelligence applications outside of a secure space. As a former federal prosecutor who worked at Maine Justice and had to handle certain issues with that were classified in nature, I am familiar with the way in which every government official is required to handle sensitive materials and classified materials. I have no faith and confidence that not only Elon Musk, but, you know, the 19 or 20 or 21-year-old interns that, you know, were working at Twitter or SpaceX last week who are suddenly showing up with carte blanche access to the nation's most sensitive materials. I have zero confidence that those materials are safe and secure. I think it poses a direct threat to our national security. And at a minimum, one of the things that we will be asking a court to examine is what data has been accessed, who had access, you know, what did they do with it, where did they send it. And my sense is there may have been violations of established federal criminal law. Now, we will see if the United States Attorney General is prepared to enforce the standards in criminal code with respect to accessing and distributing classified information. But I think this is a very serious issue and something that we've raised directly in the complaint.
Thank you, everyone, for taking the time to be here today. Again, if we were not able to get to your question, please feel free to reach out to the communications teams of the respective Attorney General's office. Thank you all. Have a great day.